Well, good afternoon, everybody. My name is David Tingstad. I'm a lawyer at Beresford Booth. Thanks for joining me today to discuss a somewhat interesting discussion that you may not know too much about. If you are in business, you spend a lot of your time thinking about how to run your business, deal with your employees, deal with suppliers, maximize revenue. But there are other challenges that go along with that. And so today I'm going to talk a little bit about directors and direct versus derivative actions and why in the world you should care about such a thing. And so I'm going to go ahead and share my screen. First of all, want you to understand the difference between the two. A direct action is something that is brought specifically against an individual. So let's say, for example, I make a representation that I promise certain things about our company directly to Bill, and those things are not accurate. That's fraud, misrepresentation. So Bill would have a direct claim against me for that misrepresentation, as opposed to a claim, which it would be a derivative claim, where let's say instead of making a representation to Bill, my company enters into a contract with Bill, and Bill is also a member of my company or a shareholder, and the company breaches the contract. Bill would not have a claim directly against me, but he would have a claim saying, hey, the company has breached that contract with me, and so that the company needs to be brought to account for that. But of course, I'm also an owner of that company, and I may be reluctant to do something about that claim. So a derivative claim, there's a case out of Delaware from years ago called Thule, where the Thule test has come into play. It's a two-step test. Who suffered the harm? Was it the entity who suffered the harm, or was it a person directly? Like in my first example I gave, Bill suffered direct harm from my misrepresentation to him, versus my second example where the company entered into a contract and it's the company that has somehow been harmed. And who would receive the recovery? So if the answer to both questions is who suffered the harm and who would receive the recovery is the entity, then the claim is derivative. So that's the basic framework. There's lots of nuance that goes along with that. But the question that you should be asking yourself is, why in the world does it matter, and why do I care? If you are a director in a corporation or a manager in a manager-managed LLC, or a member in a member-managed LLC, you have what are called fiduciary duties. And those fiduciary duties are broadly into two basic camps. There's a duty of care. Think of things like negligence or gross negligence. And you also have a duty of loyalty. Namely, you need to act in the best interest of the company. You can't take the opportunities that the company has for your own purpose. You can't take the assets of the company for your own purpose. And so there's all kinds, again, of nuance that goes along with that. But broadly, those are the two main fiduciary duties that we have, the duty of care and the duty of loyalty. Well, one of the things that goes along with that is an obligation to investigate and respond to demands that relate to derivative claims. All right. So let's use our example. We have a company that has two owners, Ann and Bill. Ann owns 51%, Bill owns 49%. And Ann is a director and manager of the company. And Ann also owns real estate, and Ann leases that real estate to the company. And so here Bill is as a 49% owner, And let's say Bill isn't thrilled with how Ann, as the landlord, is treating the company. Well, Ann is the manager and the director and owns that real estate. So Bill might complain about the condition of the premises that the company is operating under, but Ann may not want to do anything about that. And Bill might complain, well, Bill doesn't have a contract. He doesn't have the ability to enforce the terms of that lease. And without the ability to enforce the terms of the lease, what is Bill to do? Well, there are some procedural obligations that need to be met for him to make a demand on behalf of the company that would then put the obligation on Ann to go investigate that. Well, she's got a conflict. What in the world is she supposed to do with that? And so the idea of a derivative claim gives a minority shareholder or member the ability to cause the company, in effect, to bring litigation that it otherwise might not do. Certainly, Ann wouldn't want to, in effect, sue herself. And so Bill can make demand on behalf of the company that says, company, you need to sue the landlord so that the lease terms are being carried out. And then the company needs to do something with that. And if the company does not do that, then Bill has the ability to take control of that litigation himself, perhaps even use the assets of the company to fund that litigation, and Ann would lose control of it. So you can imagine, if you're Ann, you want to be very, very careful of when you receive a demand from Bill, because you don't want Bill to take control of it. Ann then she's conflicted. What is she supposed to do? She can delegate the decision about how to handle that demand to someone who's independent, not to Bill, not to herself, but she can delegate that duty to say, hey, look into this. In Delaware, those are called special litigation committees, have the similar ability to do that in Washington. And we've done that. Okay, we've taken that where you have that conflict, you have that sole manager, claims are being made. What's to happen? Well, let's appoint somebody else who can investigate and make the decision. And when that happens, and when that delegation occurs, this is one way you deal with that conflict of interest. When you make that delegation, and then that person does the investigation and says, you know what, it's not that's not a valid claim. Bill's claims don't matter. Then the company can then go to court, have the matter dismissed, because based on the company's good faith business judgment, pursuant to what's called the business judgment rule, courts aren't going to get in the way of those kinds of decisions. And so that's a way for Ann to protect herself and the company against these kinds of claims. So you can see from the slide here that when you're a single director, imagine that someone is suing the company, and the manager has an interest there involved, and the manager might want to have what's called indemnification there, cause the company to pay the manager's expenses for dealing with the litigation. Well, here again, and we've been down this road before, where now that manager, instead of making that decision him or herself, has the ability to get some outside help that's independent to get indemnification and advancement. Similarly, when you're in a situation where, let's say, you have a three-person board of directors or a three-person management committee, and one of the directors wants to buy the assets of the company. Well, that insider transaction, there are still fiduciary duties that are in play, clearly a conflict of interest that are involved. And that insider, the buyer may need to recuse him or herself to step out. And certainly all kinds of attorney-client privilege issues, things of that nature that come into play with those kinds of issues. So let me just summarize. There's a lot here. We represent a ton of board of directors, a ton of board of managers, and these issues are real. And everyone who either advises boards or is on a board needs to be conscious of this idea and be thoughtful about the direct versus derivative distinction. You see it on the slide here. And why it matters, because you have an direct obligation depending on the nature of the claim. So it clearly needs to be delineated. And then, of course, you have to have the ability to deal with conflicts of interest. So just wanted to take a brief opportunity to talk about this difference. I head up our business and real estate group here. We do advise a great number of boards. Certainly would be pleased to help you and your board. So give me a call. I'm here, 425-776-4100. You can reach me by email. Also, look at our blog, blog.com, or at beresfordlaw.com. Thanks for taking the time. Enjoy the sunshine.